Hello students, I'm Marjina Sultana, an assistant professor from Interpersonal Law College, Greater Noida. Welcome to Administrative Law lecture. Today we will be discussing administrative tribunals. To understand administrative tribunal, it is first necessary to understand what is tribunal. Tribunal is a quasi-judicial institution that resolves disputes relating to administration, environment cases, tax-related disputes, etc. So, the word tribunal was derived from the tribunes, which means magistrates of the classical Roman Republic. So it was referred to the office of the tribunal, that is, a Roman official under the monarchy, and their function were to protect the citizens from arbitrary action by the aristocratic magistrates. So this the tribunal, their function is to adjudicate disputes, determine the rights between the contesting parties, to make administrative decision and review an existing administrative decision and so forth. So it generally is any person or institution having an authority to judge, adjudicate on, or to determine claims or disputes, whether or not it is called a tribunal in its title. So tribunal is determined by its function. So why do we need tribunal? The importance of the tribunal is that it is a specialized, they perform a specialized role in justice mechanism. They take off the load, the the burden from the courts. So it was set up, tribunal was set up to reduce the workload of the courts, to expedite decisions, and to provide a forum which would be made by lawyers and experts in the areas falling under the jurisdiction of the tribunals. Tribunals may be administrative tribunals or tribunals for other matters. The provision for administrative tribunal is provided under Article 323A of the Constitution of India, and this article it was incorporated in the Constitution by the 42nd Amendment Act of 1976. Another article, Article 323B of the Constitution, was also incorporated by the 42nd Amendment Act of 1976 to deal with other matters. So, administrative tribunals was set up by an act of parliament, that is Administrative Tribunals Act of 1985. As I have mentioned, administrative tribunals owes its origin to Article 323A of the Constitution. It adjudicates disputes and complaints with respect to recruitment and conditions of service of persons appointed to the public service and the posts in connection with the affairs of the union and the states. So administrative tribunals deals with the public service matters only. Administrative Tribunals Act of 1985 provides for three types of tribunals. The Central Administrative Tribunals, that is established by the central government. Another is Administrative Tribunal for State Employees. It can be the central government may establish such tribunals for state employees upon receipt of a request in this behalf from any state government. The third types of tribunal is joint administrative tribunals, which exercise powers of the administrative tribunals for states for two or more states. So what are the characteristics of administrative tribunals? Administrative tribunal is an agency created by the statutes and they are invested with judicial power of the state. So they perform quasi judicial functions as distinguished from the pure administrative functions. So administrative tribunal is different from the ordinary court. So they don't have to follow the strict rules of procedure and evidence prescribed by the Civil Procedure Court or the, okay, not obviously not the CRPC, but they have to follow the principles of natural justice and required to act openly, fairly, and impartially. These tribunals, they they try cases of special matters which are conferred on them by statutes. But uh, in an ordinary civil courts, they all kinds of civil suits can be brought before them, and the civil courts have the judicial power to try all the suits of a civil nature. But the tribunal has to try only the special matters. So these administrative tribunals are entirely in the hands of the executive. The president or a member of the tribunal may not be trained in law, but they may be an expert in the field of administrative matters. So these are some of the characteristics of the administrative tribunals. Central Administrative Tribunals has jurisdiction to deal with service matters pertaining to the central government employees or of any union territory or local or other government under the control of the Government of India or of a corporation owned or controlled by the central government. As we have discussed in the previous slides, the Central Administrative Tribunal, that is CAT, was set up on 1st November 1985 by the Statute Administrative Tribunal Act 1985. Let's understand the characteristics and the composition of the Central Administrative Tribunal. It has 17 regular benches, 15 of which operate at the principal seats of the High Courts and the remaining 2 at Jaipur and Lucknow. These benches also hold circuit sittings at other seats of High Courts. The tribunal consists of a chairman, vice chairman, and the members. The members are drawn both from the judicial as well as administrative streams so as to give the tribunal the benefit of expertise both in legal and administrative spheres. The appeal against the orders of the administrative tribunal shall lie before the division bench of the concerned High Court. There's also state administrative tribunal, as we have already mentioned, but we are not going to discuss here. So it was all about the administrative tribunal. Thank you for watching.